on the notice to appear for a H-1B individual with a clean record. And along with me is my business partner, Emily Neumann and Stephen Brown. Emily, can you make people understand what is notice to appear is? And also Stephen can explain how this happened.
Yeah, so notice to appear is how the government initiates removal proceedings or deportation proceedings. They're telling you, they're giving you notice that you need to appear in immigration court, go before an immigration judge, and the judge will decide whether you should be removed from the United States. I want to back up and kind of give some background of this issue, because notice to appear has not normally been issued by USCIS. USCIS has been a benefits granting agency. ICE has been the enforcement agency, but now we have this NTA that was issued by USCIS. This goes back to January of the Trump administration, his executive order protecting the people against invasion. Where he basically eliminated a lot of the Biden era policies and wanted all the various agencies to expand removal and enforce the immigration laws. So that's what's triggering all of this in January. In response to that, in February, USCIS updated its policy manual to specifically state when USCIS, including service centers, field offices, can issue a notice to appear. Because up until this point, I've been practicing for 20 years. I've never seen a USCIS office issue a notice to appear to someone who's in the employment-based immigration part of immigration. So in February, they updated their NTA policy to say that if USCIS comes across someone who's a national security issue, has a criminal issue, has a fraud or misrepresentation issue, has TPS that's been ended, or specifically if they come across someone who is not lawfully present when they deny a benefit request. So for example, if they deny a H-1B extension, and at the time your previous I-94 has already expired, that extension means you are now not lawfully present when it gets denied. In that situation, they could issue an NTA. Again, we've never seen it in 20 years. All of a sudden, yesterday, we saw our first one. So then we find out USCIS shares that since February, USCIS has been initiating removal proceedings against 26,000 people already in the last 4 or 5 months. Now, up to this point, these have generally been people who were denied asylum, people whose TPS ended. That is the majority of them. They're saying USCIS has been issuing 1,840 NTAs a week since February. Some of these are fraud related, but about 500 per week are asylum denials. 100 per week are TPS case denials or TPS revocations. So now we get this revocation or an NTA issued for an H-1B holder. Stephen, do you want us to give us the background of this particular person's situation and why maybe they got an NTA?
Yeah, it's a very good question. So, in the NTA, the supervisory immigration officer lists the charge under Section 237A1B of the Immigration and Nationality Act. So 237 is our general grounds of who is removable. A1B is any alien who is present in the United States in violation of this chapter or other laws of the United States, or whose non-immigrant visa has been revoked. And they put it there, they actually defined it in the statute there, other documentation authorizing admission. So we are not talking about the colloquialism visa, we are talking about the visa stamp in the passport. What makes this case very interesting is I don't think it's at all proper. This individual, they go through, I guess, 16 bullet points here of the individual's immigration history going back to 2013 with the first entry, all the way up until recent. And, everything looks very clean throughout this history. There's no allegations of a visa revocation. There is no allegations of fraud. There's no allegations of crime. There's no allegations of immigration misdeeds. But what happens here late in the paragraphs here, the USCIS starts talking about, hey, you had an approved I-129. This was withdrawn in March 6th, 2025. And then your I-129 was revoked on March 19th, 2025. So, anytime a company terminates an individual or an individual leaves, most companies send in a notice to withdraw. And then USCIS sends a notice of revocation saying, hey, because you requested withdrawal, we are revoking it. Okay, totally fine. Nothing wrong with that. But then this individual, less than a week later, had filed a transfer to a new company. So all of this has happened during the 60-day grace period. He's only about a week in. And they say, well, because you have these revocation on March 19th, your authorization has expired. I think, Emily, truthfully, and this is why we have the title the way we do about is it administrative error, is I think they're conflating against the I-129 being revoked because of a withdrawal and the visa being revoked, and they are terms of art. But we felt it was important to have this discussion because we've never seen one for an H-1B other than somebody who maybe had a deportable arrest. And this is kind of the first time we're seeing it in the service center context for an H-1B. And maybe it's all going to be turning out that this is completely incorrect and they're going to terminate the NTA proceedings and everything. And I expect that to, I would imagine that's what happens, but it's especially before it gets around and everybody has rumors. Let's talk about this.
Yeah. And I think, as you mentioned, there's 18 different bullet points where they basically go through this person's entire immigration history. And it's a normal immigration history. He's filed transfers multiple times to multiple employers. That's not a problem. And in 50% of those times after he transferred to the next employer, the previous I-129 was revoked. They point that out. The I-129 was revoked. Your I-129 was revoked. Totally normal. That's what's supposed to happen. I really think that USCIS got a hold of some AI that searched its systems and found revoked and said, oh, look, his visa's been revoked. That makes him deportable under this section of the law, which is completely incorrect. Because in order for someone to be deportable, they have to actually overstay or be violating the terms of their visa. This person is not violating anything, and he has not overstayed. Even though he's in the grace period still counts as H-1B status, number one. The only time you can be considered to overstay is when your I-94 expires, and his I-94 doesn't expire until 2027. The withdrawal of that approved petition does not impact when that I-94 expires. There's still no overstay. So this particular officer, this is coming out of the California Service Center, either does not know what a 60-day grace period is or does not know what a revoked visa is versus a revoked petition, or I don't know. It's clearly this person is not deportable or removable. And, again, this is a first time we're seeing it. We hope it's a last time we see it. We hope this was just a one-off kind of weird case error. We don't want to panic people and make you think that, oh my gosh, if I get any kind of denial from USCIS or if my company withdraws my petition because I leave, I'm going to end up with an NTA. Hopefully that's not what happens. It's very early to see what's going on. This particular case, that they don't have their court date yet for another couple of weeks. But we did want to make people aware just that USCIS is issuing NTAs now. Apparently 26,000 of them since February, and this is the first I've heard of it.
And it
So coming,
shows, and we had talked about this earlier, Emily, that even though we think this one's improper, this is concrete evidence that they are looking at H-1Bs in some way, shape, or form. And, we vetted it. You pulled it up that this is a legitimate case in EOR, which is the Executive Office of for Immigration Review, which is removal proceedings. So this isn't fake. Because at first we saw this, we were like, we got to make sure.
Yeah,
No,
I really
it
thought
is.
it was fake because there's just no way that this person is deportable.
Yeah. So again, not trying to scare anybody. I think just trying to bring attention. I mean, we don't do removal proceedings, so.
So coming to the basic points, Emily and Stephen, is that this person is legitimately on H-1B visa, working for company A. He got laid off on March 1st week, and in about 2 to 3 weeks, within the 60-day grace period, he applied for H-1B with company B, which is still pending, which is legally allowed. Now he got the notice to appear in the deportation courts. That's a short form of it, where he's also been called for biometrics. And after the biometrics, he has been given a date for, he was been given a date
It's
to
mid-July.
appear. Yeah, and is been given a date to appear in the court on July 7th. So he still has to go to the biometrics. He still have to hire a lawyer. He can't just leave the country because once a notice to appear has been issued, it's not an option that he can just leave. He has to contact a prosecutor to see if they would accept for a voluntary departure, or probably see if they would drop the case completely off. If not, if he has to go to the court system, then that may take, even master calendar hearing might take about 2 to 3 years. We still don't know at this point of time what the immigration is going to do it. I definitely advise this individual a couple of times to do the premium processing of the change of employer to see if he can challenge this at the USCIS to see if they would approve the H-1B, even the notice to appear has been issued. So in a normal case, of course, we have seen some people with major criminal offenses that did get the notice to appear, which we have transferred it. But this gentleman, in the notice to appear, though, they did not allege any violations except that his H-1B has been withdrawn and he got filed a H-1B transfer to a different company at the same time. So he was within the 60-day grace period. So what if this is going to be the norm? This is going to be a major disaster, because anytime anybody gets laid off, we're going to get a notice to appear for those people, even if they are within the 60-day grace period. Anytime we get a change of status denied, we will get a notice to appear. Anytime we get the extension of status denied, we're going to get a notice to appear. Practically, we will have to stop doing this practice and start going to the courts.
Yeah, and I think what's frustrating with this as an example is you have a number of factors at play that is going to cause incompetent results. You have the administration is focused on numbers. I mean, there's a story out there that, Stephen Miller was yelling at a bunch of immigration officers to bump up the removal and arrest numbers. And then at the same time, you have individuals that are either getting out of federal government, being forced out of federal government, being offered early retirement packages. And so you're losing good workers. And if they're being replaced, they're less experienced getting moved up. And so, I think what you have here is a bureaucratic nightmare where you have, a push to drive numbers and data points. This supervisory immigration service officer, I think, is grossly incompetent at, his job, because even when you look at this with an eye to let's give the administration some benefit of the doubt here, there is none. One of the discussion points we had was, well, he's in the 60-day grace period, and that's discretionary, and that's true, but that still requires a decision, right? So they would have to say, no, we're denying your extension of status, um, and we're going to exercise our discretion that way. But there has to be a decision. It can't just be, bippity boppity, we're not doing it, and put you in removal proceedings. And so I checked, I pulled the case status page. His I-129 that he filed is still pending. There's nothing that he's done improper here. I hope the immigration judge laughs this out. We'll see.
Yeah, I think it's sad that someone who's already in employment termination situation, losing a paycheck, already did the right thing by filing the transfer within 60 days, now has to spend more money to hire an attorney to defend themselves against this completely improper. I mean, they're literally stating that your form I-129 was revoked on X date. You remained in the US beyond X date without authorization from the INS. Therefore, you do not currently have a valid visa. I mean, none of that is right.
And we weren't even talking about a thing about getting cute with the 60-day grace period and when it started. I mean, this was within, the notice was sent March 6th. It was processed March 19th. He had filed the transfer March 25th. This was all within 30 days. So this isn't, there's a lot of questions about when the 60-day grace period starts. This isn't up for debate based off of the facts here that, he's not at day 59 and maybe it's day 62 or something like that. And to your point earlier, Emily, even if it was, he'd still be lawfully present. It's just out of status. So again, I think this is just a colossal mistake, but it's one worth discussing so people are aware that if they do have a negative action, that, Rahul said, a denial of the I-94, a denial of the change of status or the extension of status, they're looking at this. And, with the push to drive numbers, we might see these when it's more appropriate.
My major problem, Stephen and Emily, is that if they're going to broaden up as they have issued their policy guidelines released on June 12th, 2025, that they are going to increase the number of NTAs and issued by the USCIS. Practically, let's say, for example, any H-1B that will be withdrawn means that if a person is moving from from H-1B to H-4, H-1B to B-2, H-1B to F-1, or probably H-1B and stay 60 days in the grace period. Because if the company withdraws the H-1B, which they are under obligation, because if the person leaves the job, they have to withdraw the H-1B application, they will be issued a notice to appear if this policy were to implemented as across the board.
Yeah, I just don't I really think they see the word revoke and think that means the person had their visa revoked, which makes them deportable. But this type of revocation is not revocation of the visa. It is a normal part of H-1B petitions. It is a withdrawal because someone left the company, which you're required to do. The company's required to do. What do people do to protect themselves from something like this? Again, we don't know how much this is going to expand, if at all. Maybe, hopefully, this is just a one wacky thing, and we don't see any more. But consider talking to if you're in a termination situation, consider talking to your employer and saying, hey, can you wait until after the 60-day grace period to send the withdrawal? That will give me time to file my transfer first, and then you'll get that revoked notification. That would be one thing to do. Another major thing that you can do is anytime you're filing anything that's an extension or change of status, make sure that you get the decision before your current I-94 expires, because if the decision is a denial and your previous stay has not yet expired, you are still lawfully present, even though it's been denied. And they should not issue an NTA in that situation. But if your previous stay expired, and then 6 months later you get a denial, even though all the time that application was pending, you were lawfully present, you were in a period of stay authorized by the Attorney General. They actually use the word authorized. It is authorized stay, but once it gets denied, that authorized stay immediately ends. Now you are unlawfully present from the very next day. That's when you're at a greater risk for one of these NTAs to be issued. That would be technically a correct scenario where they could issue an NTA. Haven't seen them do it yet. Instead, they do it in this crazy case where they shouldn't have.
Going back to the history, Emily, you said 20 years. I'm a little bit older, much older than you are. 30 years it's been. I've been practicing from 1995. I've never seen a notice to appear for any H-1B denial. In fact, this case, the H-1B is not even denied. It's been withdrawn because he left the employment. I've never seen a notice to appear any of the change of status denial, extension of status denial. Nothing, never seen a notice to appear at all. We have only seen in major criminal cases and in cases that involve in a lot of violations, fraud and misrepresentation. And they do allege in the notice to appear what allegations are there. And in this clearly notice to appear, nothing has been mentioned except one point that the company has withdrawn the H-1B petition, which the company is obligated to withdraw it. Emily, if you know that the Department of Labor regulations, that if the person leave the employment, it is the obligation of the employer to withdraw the H-1B. Otherwise, the employer is subject to pay the salary. So the advice that, okay, employer wait, not withdraw, may not work. Stephen, you're laughing?
No, I think it's funny that, I mean, they're going against everything in their regulations. I mean, again, this is quintessential Trump 2.0 on immigration right now. It's the refusal to follow their rules, whether incompetence or disregard, I don't know which, but it's going to continue to bite them in the rear end, but they're going to cause a lot of heartache for people throughout the process. This idea of post-bag isn't new. I don't know. Do we have an incompetent officer here, or is it a new trend? I don't know. I will say we passed some things along to a couple listservs today. Nobody seems to have seen any other than this, which is a good sign. But I will say, I do also want to confirm I'm looking at the NTA right now. Anybody who thinks we're just making stuff up, we can't publish it because it's full of identifiable information. But it did happen.
Yeah, we're very careful about vetting rumor situation to make sure we're not needlessly sharing things that are not true, and dispelling the rumors or sharing things when we don't have all of the information. But we have very confirmed information on this case. So that's why we wanted to share it today.
We have the notice to appear in our hand. I spoke with the individual 4 to 5 times. It is 5 to 6 times from yesterday to today. Anything else, Emily?
Nope, just stay tuned. We'll definitely keep you updated if we start seeing more of this, and hopefully this is just a one-off and not a new trend.
And I do think, real quick here, in terms of an action item that we had talked about, I mean, look, we don't do removal proceedings, but, hire a competent, removal. If this happens to you, hire a competent removal attorney that knows that immigration court. So many times, removal proceedings are form over substance, meaning that they're very picky on how things are done. And they might know the individuals, but if they don't maybe know the H-1B side, have them, talk with you or get a brief from a qualified immigration attorney, that can help you on this. But again, we don't do removal proceedings, so not selling that here.
Thank you very much for tuning. Anything else before we close?
Nope.
Thank you, guys. Please keep tuned. We do have every Tuesday live, and if there is any news update that comes in, we do bring in, and we feel if it's important that you need to learn about it, we do bring in. Thank you.